Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Got him easy Anglican for he's verbal Latino. I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All rise. Court is now in session. Judge Newman presiding.
I'm trying to have court.
Can you hear me now? Let's do that one. All right, this mic's not working. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's lunchtime, and I forgot which mic to use. It happens. Let's see. Test 1, 2. Yeah, let's do that one. Let's do this one. All right, now we're good. I like. It just sounds better. It just sounds better on this one. All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Let's see. We have two things right at the top of our menu today. Not menu, but our schedule. I'm thinking food. Because, as you can see, I did not, well, maybe you can't see. I got my hair cut on lunch. All of them, pretty much. I think I missed a couple. But most of my hair is cut. And I did not eat. Because eating and getting your hair cut are two things you cannot do at the same time. It just doesn't work that way. And so I'm thinking about food still. But Jinx, congratulations, you're first in chat again. Congratulations, Jinx. Because you're first in chat, we're going to punish you with internet ownership. Everything IP-related worldwide is your responsibility to fix, maintain, and educate people on the proper use of said item. So congratulations and good riddance. Good luck as well. Let's see. We've got another thing on the agenda here. We've got a poll going right now. If you missed it, we have 660 votes and 970 people here. So at least a third of you probably missed out on this. The poll is, will Donna testify in her defense? And then I do ask you to click the like button to show that you voted. 358 of you clicked the like button, but there are 671 people who have not found their way to that button yet. I'll wait. No, just kidding. I'll wait. Let's go ahead and show the poll results because we're going to get that. Well, I'll give it a minute because the votes are coming in pretty fast right now. If you cannot see the poll, open up chat. It should be pinned sort of up at the top by the pinned messages. Look for it there. If you don't see it there, then I'm sorry. You just are not an eligible voter. For some reason, YouTube determines that your opinion does not matter. We're just going to skip you and assume everyone else votes like you do. We don't follow instructions, says Raj. Hey, you and me both. All right. Where are we going? We're going back to court. Let's do that first of all. We'll go back to court. We'll be listening in. As soon as something happens, you will hear it right here. And yes, we have a 50-50 split currently. This is why your vote is so important. Right at this very moment, we would not have a winner. It would be, it's tied. It's literally tied. Your vote could make all the difference and sway the ballot one way or another. Will Donna testify in her defense? Yes or no? Get your vote in now. It matters. Your vote matters. Not that it will matter to her, but it matters to us. All right. Michelle Johnson, member for 7 months. Welcome to the gallery. Thank you, Michelle. I appreciate your support. Can I vote twice? You can, but you'll need to make another YouTube account. YouTube's not that picky. As long as you make another account, they'll let you vote. I'm not advising that, but yes, there's their ways. All right, voted just in time. I think we're about to close it. I think we're about to close the poll. There are 2 other witnesses we expect to hear from before Donna testifies, if she does. But before those 2 witnesses testify, we expect the judge to sit down with the prosecutors about in 11 minutes from now and say, all right, Defense, what'll it be? Is Donna going to exercise her right to remain silent, or is she going to exercise her right to testify in her own defense? She can do either, but she cannot do both. This is a choice that has to be made. You can't sit on the fence and just say, I'm not going to choose. I'm not going to choose. Now's the time to choose. I think her lawyer should advise her not to testify in her own defense. I cannot see it being good for her. But I don't know if she sees that it's not good for her. So that might happen. All right, let me change the views here so we can get everything on that we need. All right, Michelle, thank you very much. Welcome. Welcome to the gallery. And also, super sticker. Thank you, Michelle. I appreciate your support. Loves Bunny Hop, member for 2 months. Says I've been watching way longer. Yeah, the official count is low, but your name looks awfully familiar. Thank you for your support. Glad we've got you on for 2 months at least so far. Let's see, Georgia will destroy her defense. Oh, okay. Georgia, you saw Georgia against the last witness, who was a lawyer. And Georgia was basically driving that boat, okay? The lawyer was struggling to find ways to not answer questions and failing miserably at it. Imagine now Georgia, with all her expertise and experience, focusing her keen wit and skill on the non-lawyer, Donna, on the defendant, on the one who's emotionally wrapped up in this and has a lot of things that need to be explained that the explanation just hasn't held water so far. It would be amazing. It would be amazing. And she wouldn't be making the exactly comments that she was in this one. But she would be epically just awesome. It would be so cool to watch. Kiki's Garden just gifted a membership. Congratulations, Cynthia Burnett. You're the recipient of Kiki's generosity. Kiki, hope your garden's doing well. Aaron Blackman says, all right, I thought I'd share. There's a video of Alan Jackson cross-examining an expert in a murder trial when he was a prosecutor. Masterful. If you're looking for something to watch on a day off of court, I highly recommend. Aaron, if you can, send me the link to it on the burner phone. I probably can't show it on the channel, but I'd love to watch it. That sounds like something that would be really interesting. All right. Does that noise come through? I've just got like a negative... I don't know, what is it? Okay, it stopped. We're good. All right. State's lawyers are fantastic. They're doing a really good job. Sounds like a white noise machine. I think it was actually our equipment outside. It's a little quieter now, although there's a little hiss. This mic is quieter. We'll switch. We'll do this one. All right, I'm all about the audio. All right, speaking of which, this court has had amazing audio. Big shout out to the pool TV photographer and videographers who have just mic'd this spectacularly. We've pretty much heard everything we wanted to hear, including the videos. And we're talking interrogation type videos that are usually recorded on a potato. We've heard a lot of good stuff. Some of the old stuff, it was done poorly, but I think we heard about as good as the jurors heard in this one, which is rare. Can't wait for state rebuttal on Friday. Let's see. Peter Tragos is amazing. Love his insights. I loved having. Oh my goodness, we had Rob here on the morning session. I don't know, not sure if he's busy with work or not, but we had Rob here, and getting his commentary and analysis and opinion about, as somebody who works in the field that he works as well in family law, and clarifying some of this. Some of us, the little people, could understand. It was great. Rob from Law and Lumber, appreciate you. Thank you, my friend. Good to have you here. All right. Anything else? I think Kurt was here as well. Kurt, if I didn't shout out, hi. Hello, Kurt. Good to have you as well. Let's see. Still don't understand the defense case. Divorce was actually amicable. Donna was actually nice. Charlie did all by himself. Wendy's the one. Yeah, Lady Laura, there's points where they're like, are they insinuating that Wendy was like the driver behind this? Are they? I'm not sure if you're trying to drag Donna out from under the bus or shove Wendy under in her place. I'm not sure which one they're trying to accomplish. Sometimes the defense gets up and cross-examines a witness in this trial, and it seems like they're just scoring own goals, right? Kicking the ball backwards into their own net. Conceding a lot of stuff, which a lot of times you do in a case where you're not arguing some of the facts of the case. You both agree on some things, but other things you disagree. We knew that was going to happen. Some witnesses, they didn't even cross-examine at all. They're like, yeah, we agree. Everything they say, yep, that's part of our narrative. So it's been an interesting trial that way. All right, let me close the poll out because we have, we need 5 more votes. 5 more votes would take us to 1,000. Let's see, 4 more votes, 996. Get your vote in now. It could be the deciding factor. We are so close. It is neck and neck. 3 more votes, 2 more votes, 1 more vote, and we're done with 108 came in right at the last minute. Sorry, I know some people were voting when I cut it off, but that's how it works. Let's see. This is where it comes down with 1,000 votes. Results in chat. And it is as such. Will Donna testify on her defense? No was 51%. Yes at 48%. That was 1,000 people voting. So really, we're on the fence on this one. No by a nose. No by 1 nose. All right. It is 2:12. We are this late in the afternoon because we had some hiccups this morning. We had a witness who who did violate the sequestration order because the defense told her it was okay to do that, even though they asked permission and they did not get permission. They said it was okay, so she sat in the courtroom for testimony and then referenced that testimony, like literally, you just heard her say such and such. I just learned from this. That was bad. That was bad. That was the second time the defense has had a sequestration oopsies in this trial. Any idea what trial you'll stream next? Thanks again. I don't know quite yet. We'll have to look. Judges come back. This is something we have to listen carefully to. This decision whether the defense is going to call Donna to testify in her own defense. It's her choice. The lawyers don't get to choose. They get input, but they don't get to choose. So we'll give them a minute. It might be coming in. This is so suspenseful. This is the moment we're all waiting for. And it gets quiet again. We'll keep waiting. You mean they screwed up? They did. They screwed up, but they said they thought they were doing it right. There wasn't really a punishment. There may be, the judge has said they might have a curative instruction given to the jury, but it wasn't given at the time.
Hush. I'm trying to have court. Don't raise your voice.
Judge Clark coming in here, laying down the law. They didn't give it at the time, so it might be given later in the instructions, but it seems less effective the further the curative instruction gets from the testimony that it's relative to.
Don't put a diplomatic plate on a hoopty.
You guys are finding all the sound effects. That's Judge Simpson. So we'll see what happens. We'll see what happens here. I know that defense is very close to the end of their case. They've got 2 witnesses and possibly Donna that we know of. There could be more, but that might be it. Charlie was, when he was transferred to Leon County, the transport did stop and get him Wendy's. He got Wendy's, and oh my goodness. I think, who had that? Tanica's 2 Cents has that video. And Charlie's face, he cannot contain the glee on his face at getting fast food once again. It's clearly been a while, and he is so excited to get his nuggets and dip, and yeah, like a kid at Christmas. Even if you're eating it in the back of a transport van in handcuffs on the way to jail. There's a video of Charlie eating at the back of a transport van. That's there.
In front of the Walmart.
Yes, it was. It's important that it was not at Wendy's, as in his sister Wendy. It was at Wendy's, the restaurant, the fast food restaurant in the United States. Serves burgers and chicken and such. Just came across the video on break. It's a good one. Where's the video? I saw it on Tanica's 2 Cents, a fellow content creator who's been following this case, and I guess she probably FOIA requested it.
I'm not going to argue about semantics here.
It's a long video. Most of it's just like road video or noise or somebody sitting in a transport van. There's not a ton to it, but.
Happy birthday.
Sheriff took his handcuffs off in the back of the van for him to eat. Took one handcuff off. The other one was still attached to his waist shackle, but they did. It's hard to get your hands to your mouth. You know, you have to bring your mouth down to your waist practically. It's not easy to eat that way. But it was nice of him to give him a burger. Okay. Tanika has it. Okay. Belly chain, waist chain. I keep saying her name wrong. Tanika? Is this not? Am I putting the emphasis on the wrong syllable? Tanika. So it's just an emphasis thing. It's not like I'm getting the letters or the sounds in the wrong order. Tanika. I'm sorry, Tanika. I do apologize. You can call me Recovery Addict as a sanction. You can call me a Recovery Addict. All right. I apologize. You know I'm terrible with names, right? I'm terrible with names. But do go to her channel and watch it. Lady Laura, that's a little different. I was adding the T on the end. I think it's important to get every syllable in there. I'm just saying you can put the emphasis in a different place. You guys are terrible. All right. Any minute now. We're 2 minutes late from the judge coming back from lunch when he said we would, and we're anxious to hear the defense's decision. They had an extra 15 minutes at lunch today to talk to Donna about her decision to testify. It sounds like they felt the decision still hadn't been finalized, that it hadn't been made, and they still needed to discuss some things. Obviously, it's important to wait. I think it's important to wait and not just get this out under, like, as soon as the defense starts their case. Are you going to testify or not? Because a lot can happen. You can call a witness and you could not get the testimony you wanted out of them, or you could call a witness and get more than you thought you could out of them, and suddenly you're in a better situation. So they're going to analyze what they have coming up, where they think they are with the jury as far as, you know, getting their story and their evidence in, and then decide if Donna would be helpful or hurtful to that, advise her that way, and then she gets to choose if she follows the advice or not. So we go to closing if she doesn't. No, we still got 2 witnesses that will be today. I just don't know if you guys are giving me a hard time about my pronunciation. I just don't know if she's going to testify or not. Those 2 witnesses could take all afternoon. Here we go. Judge is coming in right now.
All right, 2 matters to briefly address before we bring the jurors on.
2 matters. I was only aware of 1.
First, concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise. Raise your right hand.
Okay.
Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Mr. Scalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
So, the judge asks if you waive attorney-client privilege, which is a sweeping, yes, anything we talked about, she can talk about. Defense says we'd actually like to waive only in regards to a certain issue, so not everything's on the table. We'd only like to have this little bit allowed to come in. We don't want to release.
Mrs. Adelson, do you understand
everything
the
to the
scope of the
prosecution.
waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
No, sir.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
She's not going to.
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Miss Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
One horse, one rider.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not.
Judge is not budging.
I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors. Let them know that we will get started momentarily.
Okay, the judge sat down on his chair, which officially means we can keep the cameras rolling in the courtroom. But for safety reasons, we take the seal shot instead. The judge is not being pushed by this argument that, Your Honor, it's been several weeks of trial. We need to go over everything with our client. First, we need to go over it, and then go over everything with our client to see if she wants to testify. Why the stall here? Why are they? I mean, were they not here for the trial? They were. I saw them. They were here every day. There wasn't like one lawyer missed a day or two or something like that. Everyone has been here for the entire trial. They've heard what we heard. The judge is right. There's no special consideration given to anyone else. Anyone else in this situation has to make the decision right now, and he's allowed plenty of time. Gives an extra 5 minutes, and it also acknowledges that we are in fact nearing the end of the case for the defense as well. They've heard everything that's come in. They're afraid of cross. They should be, Karen. They're 100%. They should be afraid of cross. That's the only thing you're really afraid of when your client takes the stand, unless they just can't follow instructions and answer simple questions. They're purposely going to stretch out the next witness. I don't know if they are. I don't know. I think Donna wants to against the advice of her lawyers. She did not have any facial reaction to the judge asking her the question. I didn't see trepidation or anything. Looking back at how she looked when he asked the question here, let's see. I think we've got somebody on the phone. I'm not connected right now, so I'm not sure if I can get this in time. But
call from Angela.
Hey, Angela, how are you doing?
I'm doing good. I know we're due back any minute, but I just want to say something. They still didn't decide whether or not she is going to testify, but they had months, not only with these lawyers, but the lawyers before that. Also, didn't she initially want a speedy trial or something, if I remember correctly? Or it was someone else who wanted?
They're back.
Okay, bye.
And although the proceedings are public, that has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
His approach, we're not going to do this for very long.
All right, so here at the end of the trial, defense makes the motion. We'd like Donna to be able to participate at sidebar. She takes her handheld amplifier and headphones with her, so she is going over. Bailiffs are now following, saying, okay, what's happening here? We have seen this before, I think also in the state of Florida, that right for a defendant to participate in any meaningful portion of the trial that could have an impact, including the sidebars, is recognized. But why they're waiting till, what are we, day 8 of testimony? To say we'd ask for Donna to be able to participate in the sidebars? What about all the other days? Did he just think of this today? But this particular sidebar weighs heavily on her decision to testify. So maybe that's one that they think this is actually really pertinent to this. They have complained one more time about the Peanut Gallery. Who's the Peanut Gallery? The Peanut Gallery is the gallery. And I think it's disrespectful to the court to refer to the gallery as the Peanut Gallery. Often referred to as the cheap seats. It's the peasants. It's the peasants watching the circus that he's referring to. And that is a little bit rude. I think he said Peanut Gallery. He did. It's rude, and it lumps everyone together. And in that Peanut Gallery, we have some phenomenal pool media. both still photographers and video, running audio and video. We have amazing reporters who have been there day in and day out consistently. We have family members on both sides, and we have interested members of the public who are there. And so lumping them all together was a little bit rude. All right. Let's see. Who's back there bothering them? The bailiff's like, this is the first time I've participated in sidebar. I love the state's demeanor, the arms crossed. Maybe defense is worried that if Donna takes the stand, the gallery will burst out laughing with some of her explanations. That's a legitimate fear. They shouldn't do that. Now we have Georgia with hands on the hips, Sarah with her arms still crossed. Lip read anyone? No, won't be able to lip read. This is still, defense asked for this sidebar, and this is their initial argument. The judge is still hearing the initial argument. So it's a lengthy argument. The state hasn't weighed in yet. Judge has said this won't be a long one. Notice Donna did her hair nicer. You're assuming that, or thinking that maybe that means she might be taking the stand. She's prepping for her time in the camera and the spotlight. The male defense lawyer said the peanut gallery is making it difficult for his client to decide. It's okay. Judge Everett doesn't have expressions. He's got a poker face. We're live. We can't speed it up any faster than it's going. I know that we like, we're in today's day and age, we can skip commercials and zip through to the good stuff a lot of times with movies and, watching, recorded content on YouTube. I love the pace of court. Even the sort of the repetitive nature of admitting evidence and laying foundation for it and everything. I love the system and watching it work and every piece fall into the right place and have to be done properly. I love that. And so I'm probably more patient with the slow parts than most people. I struggled a little bit this morning because I didn't see the relevance in some of the testimony we had this morning. But I think she'll take the stand. Maybe they're trying to set it up that she didn't receive a fair trial. Well, here's the thing. If the lawyer heard somebody laughing behind him, it doesn't mean Donna did. Donna probably didn't, but it's not Donna that we're worried about, or the lawyer. It's the jury. The jury, if they pick up on the public perception of something, that would be inappropriate. I was watching You and Me Both. I enjoy the condition of tinnitus in both my ears, a different pitch in each ear, so it's fun. It's fun. They're always ringing. Bree says, I lured my sister here to RA's channel through this recent update. Haha, you can't miss a possible Donna moment. Welcome, Bree's sister. Good to have you here. If she didn't try to flee to Vietnam, she wouldn't look so bad, dude. Come on. Okay, Jamie, the flee to Vietnam, we're about to hear that. The two issues the judge addressed right after the break. The first one was Donna has to waive attorney-client privilege because she did have an attorney that advised her and talked to her about her state of mind and her travel plans right after her son was convicted. And that's the time she was buying tickets and looking for non-extradition countries. So that is coming in. It sounds like that waiver has been appropriately granted and given. But the next portion that the judge wants is the answer to will you testify or not? And defense is dragging their feet. just dragging their feet. And I don't know what the benefit is at this point. Like, do they honestly not know if it's a good idea for her to testify or not? Are they really just like, we really have to weigh this. It's going to be close. It's going to be close. I don't see that. I don't see that Donna's, the cost analysis. What is it? Not profit and loss, but the cost benefit analysis. I don't think it's that neck and neck on this one. I don't think they've given her the advice that she needs. I cannot hear the sidebar on this one. Some courts we can. I can. Bringing the jurors in with no answer? Or was the answer provided at sidebar? The sunk cost fallacy. It could be decided at sidebar and we just don't know. But it's not on the record. If it is, I think this is something that would be on the record. I guess sidebars could be on the record. Man, now we have to sit through two witnesses to see what's happening.
All rise. The reentering the courtroom.
Judge cracks his knuckles, the knuckles of justice. Hit that too many times. There we go.
Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you.
This is like cleanup batting. I mean, they're trying to dot the I's and T's.
At this point in time, the defense would call Marisol Descalzo.
Dotting T's and crossing the I's, or vice versa.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay. And I want to direct your attention specific to the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yeah. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it. and we decided that we needed to call ethics counsel and call the Florida bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay.
To a
At that point in
country.
time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Miss Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
Okay, state gets to ask probably extradition
Cross-examination.
area as well. I think they can go into that. Do you advise her to go to Vietnam?
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed
Thank you so much.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
She answered that very carefully.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight?
As her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second.
Wow. Very careful answer in there. She did not say that she wasn't aware that they were looking for non-extradition countries. She said, I didn't know exactly one way or another which country they were going to end up at.
Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor.
Wow.
Mr. Scalzo, the prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
But now you have to explain the extradition questions.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
Okay. And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
be the last witness.
Defense would call Sarah Newhouse.
It's very important that she come in from the hallway, not from the back of the courtroom. Looks like they've gone out in the hall to get her. This could be their last witness, or we could have Donna up next. And it's possible the judge could have given them additional time. The meeting might end early. It's 3. It's almost 3. By the time this witness is done, it's going to be at least 3:30, depending on how quick it is. I doubt it's going to be extremely lengthy. It's not unheard of to wrap that early in the day, especially if we're ahead of schedule. She comes with the fancy bag. Where's the bag from? Somebody tell
Please
us.
come up to the witness stand. Raise your right hand down. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
These would be excited utterances.
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I'd move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, objection.
A lot of qualifications.
Well, there's just...
Members of the jury, we're going to take a brief break. The bailiff will take it to the jury room.
Jury, out you go. We're gonna. The bailiff has to sprint over there. It's like they're one bailiff short in this courtroom always.
You can be seated. If anyone needs to stretch their legs or use the restroom, please do it now.
All right. Greeners has provided a link to the Simply Modern vegan leather tote bag for women that the witness has brought in. Looks like it's available on Amazon for the low price of $74.99. So it's a big purse. That's the medium size. You guys were saying it looks like luggage. There's a larger one apparently. This is just the middle. This is the middle. So there's that. For those of you who want to order this like Judge Stephanie Boyd in Texas. Let's see, let me get this up for you. Here we go. Courtesy of Greeners, this is an affiliate link to that purse. It doesn't cost you any more if you buy it using that link, but it does reward the channel with a couple dollars. It's a nice purse. It's a nice purse. Knuckles of Justice. I do need to count that one. I heard them right as the jury was leaving. They did that. We'll count that really quickly. That brings us up to the round number 69.
It includes Wendy Adelson saying this is the worst day of my life before the call connects, and then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments.
That's hearsay.
Fine. I understand they don't tend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
And as I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back in the jurors.
You don't have to snip it again. Snip it in the butt. Or nip it in the bud. One of the two. Pretty easy to do using QuickTime if you're on a Mac. Load the file, click the trim button, drag the slider in, play it once through to make sure it's right, export, done. Bob's your uncle, right? Just that quick. How many times can he pop his knuckles in a row? I think they have like a 30-second reset. I wish Georgia had pushed a little harder for a direct answer, especially on the extortion, or not the extortion, but on the extradition issue. Was Georgia or Sarah? I think Sarah was the one doing the question.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Okay.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
What
Have you
about
ever met
gnashing
her?
of teeth?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know.
Correct.
And do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the report.
Please sit down. As to the hearsay, sustain.
No further questions.
Redirect.
No, Your Honor. We'll just strike the question from Ms. Kappelman.
Members of the jury, you are to disregard The last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
No, because we're done.
As to your exhibit, do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break. The bailiff will take you to the jury room once again.
Bye, jury. One more time. In, out, in, out, in, out. Jury's got their steps in today. Let's see if we get the answer here now that the jury's gone. We're just waiting for him to do a quick edit on the video for Exhibit 71. Or Defense 71, I think it was.
Everyone can be seated. Please make all necessary redactions and changes at this time.
And Judge, tell us what's going to happen. What's going to happen with Donna? Is she taking the stand? Defense attorney is currently Googling how to edit a video in court. Got no audio. And we're wandering. We're slowly... Oh, no. Here we go. Sound?
If there are no other witnesses for the defense, it is time for the decision to be made.
Here we go. Here we go.
I can tell the court that co-counsel and my client are deep in conversation.
She nodded.
I am capable of seeing that, Mr. Zellman.
She nodded.
No narration.
I'll narrate it. This should have been done so long ago, but the decision's literally being made as we watch. Defense has no other witnesses. It's now or never.
Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
Depends if she testifies.
If not, if they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Yep.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we've discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson. Can I have a few minutes, please?
Why?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
Don't move a muscle. Don't go anywhere. I would not leave for anything. It could all. We have 5 more minutes. We have 5 more minutes. Set a timer for 5 minutes.
5 minutes, counting down.
Okay, we have 5 minutes. We have 5 minutes for Donna to now discuss with her other attorney. She gets 5 minutes with each of them. The same thing. She says, I'm not prepared. I haven't had time to consider this affects the rest of my life. Yeah, it does. It sure does. Oh, man. Hey, Mods, was that intentional on the last one? Just checking. I'm not sure. I didn't see anything. Let me know. Okay, everyone, please be respectful in court. Be respectful to everybody. I hit someone accidentally. It was me. Okay, I have to unhide somebody. I thought it was somebody else. I thought it was a mod. Chat's going really fast. I snipped somebody. If for some reason you're not able to chat and I did something, reach out to me on the burner phone. You fixed it, Samantha? Okay, thank you very much. Okay, I have never seen this happen in court before. I've never seen this. I've seen them give a break and say, discuss this. We want to talk it over one more time, especially if you feel like, well, let's see what evidence came in this time. Give us a minute. We'll talk it over. Give us 15 minutes. They've had several days of, we need to talk with our client about this. The judge has been asking this question for several days. Is she going to testify or not? And they're like, well, we need to talk it over. And they keep talking it over. They've now had all that time, plus everything leading up to this time in court, right? The entire lead up in trial has led up to this moment. And Donna is still responding, I don't know. I just have to give it more thought. I'm sorry, you don't get to make that call, unfortunately. You have to choose. We're at a fork in the road, and we are moving forward. We will be on one of 2 paths, but you have to choose. Please testify, Donna, says Selena. Please testify. Either way, this is a big decision. If she testifies what the judge said, you will be cross-examined by one of the prosecutors. That will happen. It will not be pleasant. Kelly H., thank you for the super sticker. You make a good judge. I don't think I could be a judge. I admire good judges like this one. Judge Everett is being extremely fair. What can judge do if she can't decide? Well, man, I don't know if there's case law on this. If a defendant is intentionally not choosing to stall the case, I'm thinking back. The closest thing I've seen is Daryl Brooks. Daryl Brooks is probably the closest case where I've seen something like that, where he forfeited a right because he was stalling, intentionally stalling, and he forfeited his right to do something. I think the judge could say she waives her right to testify. The judge would never say you waived your right to stay silent. You have to take the stand. That would be, oh my goodness, appeal granted. But I think she could lose her right and say, if you do not choose, this choice will be made for you because we have to go forward. I can't force you to testify against, in your own defense. But your failure to choose is going to make the choice. Yes, this judge is patient. It wasn't 5 minutes. Yeah, I told you. You shouldn't have got up and left.
Gentlemen, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion.
Aaron,
we are not finished with the colloquy quite yet.
Patricia, thank you so much for the super chat.
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on.
He said contempt. He said contempt. And that affects the
The
attorneys.
question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Okay.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with the counsel?
You have 5 minutes. May I have 5 minutes, Your Honor? Okay, she's not going to testify. Let me just say, as interesting and intriguing and fascinating to watch as it would have been had she taken the stand, that was the right decision. I do think, at this point, having heard all the evidence, assuming there's not going to be any rebuttal, that she is going to be convicted. I think the jury will find her guilty, but I don't think that she should think that her not testifying made the difference, because it didn't. It didn't. I think her testifying would have solidified her guilt. She adds that at this time, well, that's the time. The time is now. So that's when she gets to choose. So how she feels right now, that's it. I think she does want to talk. I think she might talk. I think she might give interviews or something.
One matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors, or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room.
Excuse
me.
The
defense will rest. We will send them home for the evening. We'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Wow. Closings on Thursday.
Your Honor, can counsel have a moment to confer concerning whether or not we are going to rest at this point?
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring.
What?
Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
We just went through this whole process where we said, do you have any other witnesses? You said no. We did the whole colloquy with Donna. She wasn't sure. We got 5 minutes with one lawyer. She still wasn't sure. We got 5 minutes with another lawyer. She still wasn't sure. Judge forced her to make a decision. She said no. You said we're going to rest. And now you said we might call other witnesses, though? This is crazy. The Patricia Bird thing. Let me explain that really quickly. Patricia Bird, one of the jail, I think she was one of the jail mates, right? And there was talk about how she was on the defense. I think defense raised the issue and said she was on our witness list. And that's why. And now they're stipulating that she never was. So that was a false statement made by the defense in the form of a question to a witness that's just been glazed over. We fixed it with the jury, but it shows that defense was playing dirty and sneaky. Oh, man. This is a hot mess. This is so bad. Can Donna change her mind? I imagine up until when the jury comes in, yes. Even right now, she might change her mind. But once they've rested, the case is closed. I mean, the evidentiary portion is closed, and it's done. So I was right. I told you I had the gut feel she was not going to. I'm going to claim a point for that one. I'm seldom right on this channel. I like to brag when I am. So if you'll give me that. This whole case is out of order. Till arrest happens in front of the jury. Yeah, the decision can be changed right now. I don't think it will. But then defense saying, let's see if we have any other witnesses. What are you going to do? Call Charlie. I mean, if we're just stalling for time, looking for entertainment value, call Charlie. He's in Leon County. Let's bring him up. Jan, we are going to cover some of the jury instructions. I think those instructions are key to the decision the jury makes, and hearing the wording that the jury is going to hear. I know they're going to be read that as well, but I'd like to hear the battle between the two sides as they fight over the wording.
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualify under hearsay exceptions. The state's indicated that they're objecting. If I could just have a moment.
You've had moment after moment after moment. The state is objecting to these 2. They have so many moments. These are new exhibits that have not been admitted so far. They think they get past the hearsay rule, which would be a common objection. You know, you shouldn't admit that because it's a hearsay statement, a statement out of court. But it's clearly not something that's been admitted already in the phone calls or the text messages. Would they call Charlie for sentencing? I don't think so. Call Charlie. What could it hurt? I think it could hurt. It's just reaffirming in the jury's mind, yes, this is the person who was already found guilty with the same set of facts. Donna doesn't seem like she's at peace with the decision she made not to testify, and honestly, I don't blame her. Not knowing what's going to happen with everything up in the air for the rest of her life, you know, in the next couple days in this courtroom. You might have a lifetime to second guess that decision.
Mr. Zellman, concerning the items, we do need to move on so a ruling can be made.
I've never seen this type of stalling at the end. Does she agree? the judge is not going to just put up with ignoring his instruction here. Not huddling with your client is not going to fix it. At this rate, no verdict ever. We're just stalling. We're just stuck in this loop where defense needs another moment.
Your Honor, yesterday the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client.
Are you doing rule of completion?
Completeness.
Yeah.
We are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is, I believe it's States 51. No.
The state's going to object to this. What, relevance? Ask him what the evidence number is. 51? So we're getting the diaries in, or the calendars, all the scheduling. This is wild. It's an ending that's just dragging out the inevitable. There's no goal other than to stall for time.
Cattleman, concerning these items, was the state's argument?
The state's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents, and the state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by...
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023,
she has to
witness
testify.
Testified concerning that.
She has to testify if they want that.
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted, not that she was...
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. These are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just a moment.
Defense is a little mad about this. There's going to have to be case law that supports that. The judge says, yeah, if this is a recording, you got one comment in a recording out of context. Yes, rule of completeness. You get the full recording if you want it in. But a diary with a whole bunch of just different
The argument
entries.
for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband, and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you had already made?
The only entry from the 14 planner that was admitted, has been admitted so far in this trial, is the page that shows
The license plate number.
License plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor. And for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
Okay, the jurors are about to hear that the defense rests.
The state has made I want to check the redactions on
Can we just have a moment?
Video.
Donna's having a conversation there with
I believe this is just being admitted without being
defense.
published, correct?
That's correct,
Yep.
Thank you.
Jurors are fine to come in.
Do you think she's having second thoughts? Jurors are coming in.
You're entering the courtroom.
Everyone can be seated. Defense may call its next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, Is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Donna looks back at Harvey. We have a poll up with all the evidence in. It's now time to decide if you were on the jury, if the state has won you over to their side, or if you think they've not done enough to meet their burden.
Everyone can be seated.
Simple yes, no question. Did the state
please open your
prove that
copies
Donna's
of the
guilty as
jury
charged?
instructions? My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
I like that he's not reading everything, but we don't know what the titles are this way.
No, Your Honor.
No, sir.
3.2, Statement of the Charge. Any requests or changes?
Not from state.
Your Honor, the only request that I would make is that the name of my client and the names of the charges do not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note.
I don't recognize the name in all caps. I am the living man, not the entity mentioned on here. Yeah, that was funny. No caps. Lawyer's going all sob set.
Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases.
Sounds like a fun college class.
As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
The state does have a...
As to the next paragraph
man answering.
concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
Lesser included. This is a big deal. Lesser included often results in a compromise verdict. If there is a holdout.
Just confirming my recommendation being approved by our client, Your Honor.
Lesser included is a crime that is less serious, but sort of wrapped up in the larger crime, where if the jury finds that the larger crime was not quite met, they might find that the lower one was. So you might have, someone's charged with vehicular homicide, and a lesser included might be reckless driving. And they say, well, it didn't prove vehicular homicide, but we will find you guilty of reckless driving. Knowing that there are lesser includeds will be interesting. It will also, lesser includeds lengthen the jury instructions considerably, because you have to get the instructions for all.
Defense would request the manslaughter lesser.
Defense asks for manslaughter.
Second degree lesser, are you requesting that as well? It's category 1.
With the
They haven't made the decision yet?
Although it's a category 1 lesser, it still carries the same penalty. So we are not requesting second degree.
Is the state requesting second degree as a category 1 lesser?
Yes, sir, we'd be. Yes, sir, we'd be requesting all lessers.
Well, all category 1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
A couple more minutes, we're going to close the
For
poll.
the indictment, we would request his full name, Your Honor.
Acceptable, sir.
If you find Daniel Markel was killed by Donna Adelson, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but is either party requesting.
Just a moment, Your Honor. I would agree with the court's conclusion there, Your Honor.
Mr. Evans, Ms. Koppelman.
No objection to removing.
Just the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime.
That instruction does say if you find that Donna killed Dan, and we know that Donna didn't.
As to count 1,
it'll
the
explain
state is only proceeding
that
on
connection.
the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Those are the 3 things the state needs to prove for that charge to stick.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase.
Camel geese.
Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation, that will be removed.
Camels have humps.
All right,
Camel case,
instruction
some big, some small.
3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
No, sir.
They're flying through these jury instructions. The judge is pounding out the edits on his keyboard. Getting alerts of an alleged armed individual near UMass Lowell South Campus in Massachusetts, Middlesex County. Just a heads up if you're in that area.
7.4, second-degree murder. Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead.
That one's a gimme.
Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
The second definition, an act is eminently dangerous to another and demonstrating a depraved mind, that must be given. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on?
It's going well, Abel. Welcome. Good to have you here.
Well, A and B will be split by an or. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel.
We're going to end the poll right now. We've got 1,121 votes, so give it just a moment more. The poll is, did the state prove Donna is guilty as charged, yes or no? Just one more minute here for people to vote.
Concerning the State versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
And does the defendant agree with that concession?
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead.
We just need a moment. Okay, I'm ending the poll right now with 1,198 votes. 100, oh, that's, okay, 1,200 right on the button. There we go. I'll post them right now. This may not be a surprise to many people. Yes, 91%, no, 8%. And of course,
Mrs. Adelson, do you
still
understand
1%.
what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
Yes. She said yes.
Please discuss it with the matter.
Thank you.
We need another moment to discuss something with the attorneys. It sounds like it gets I get the feel that she's just dragging her feet. That there is like, she sees an inevitability ahead of her. She doesn't like what's coming. And she's just, if I complain enough, it can't go forward. Did retweet a little video out of Lowell, Massachusetts. That it purports to show somebody potentially with a firearm up in the area just walking around. The police are taking it seriously, asking people to stay inside. Shout out to Brandy who retweeted it first.
Adelson,
Brandy
do you
Churchwell.
understand the concession that is being made as to justifiable and excusable homicide?
I understand that.
You are giving your consent to this.
I am.
Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We concur, Your Honor.
In order to convict of manslaughter by act, that paragraph will be given.
Lowell.
The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
No, Your Honor.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested.
No candy today. I had a few Goldfish Old Bay flavored. %'s always missing in the polls. YouTube steals it. I think it's margin of error. Let's see, chat is going very fast. I do apologize, especially
as to the first paragraph where it says attempted homicide cases.
We're not measuring this for the completed offense.
Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for the
Correct.
completed offenses.
I believe that instruction must be given for first-degree premeditated murder, and all references to attempts of any other sort will be removed.
Nan, thank you for the
State
super
must
chat.
prove the defendant intended that the killing of Daniel Markel occurred.
That's pretty much done. I'm not sure yet. Don't have an answer for you.
As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
You have to intend the act, but you don't have to intend to kill him.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor.
How many moments the defense got today? I think this is like 10. It is the judge tapping on his computer. I like to imagine he has like a mechanical keyboard like this, LED and everything, all the cool lights that.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
That's fine.
And don't contact me on that, Judge, and I'll let you know.
These are super noisy.
Yeah.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as the second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those?
Lacey, thank you. Appreciate the support. The likes help a ton. And your super chat helps as well. Thank you. I appreciate that.
Are you asked?
For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I would skew down the principles already connects with size. Yes, sir. No, there's no evidence that the defendant in this case actually possessed the firearm, so no, we're not requesting it.
It will be removed.
That's interesting because if she's a principal, doesn't the firearm
3.5
aggravator
sub
still
B
apply?
principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proves beyond a reasonable doubt. And then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say it again?
Element 3, the bracketed portion, it says crime or attempt. The crime that the state is requesting, is that first-degree murder?
Yes, sir, but I don't believe it. I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime.
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
Judy, what are you using it for? Is it like for filming
This
or?
crime is the appropriate one given the standard instruction.
I'm going to look at the standard briefly, Your Honor.
The judge has hit the backspace
The
button
other
about 50
person
times.
that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
They haven't shown the male on the prosecution side yet, but he's probably just on for this.
The individuals, Secretary Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McManawa, and or other persons.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction.
3.5 sub B, element 3.
Yes, sir, but I'm saying for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, we'll read the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
Just doing away with the firearm part of it.
That will be omitted.
And Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
By my reading, this is the new instruction.
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed.
Judy, I'll give you a link right there. That's an affiliate link. It's the brand.
Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All 4.
It's an entry-level equipment as far as brand goes. That's the brand of lights I've used for 3 years and love them. I have a couple of their tripods. They're okay. They're not fancy, but they're lightweight and it will work for you. And it has all the parts you need. Amanda, you did not miss anything other than the decision to testify took about half an hour.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with.
She chose not to.
Charles Adelson, Catherine McBanawa, and or other persons to cause the first-degree murder to be committed either by them or one of them or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Catherine McBanawa and or other persons. So I think it could be.
You're just requesting an and or between the names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Because there are multiple ways to get
Going
there.
back to the indictment, these are the individuals that are within the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding of and or are, it can include, basically, if you put something or, I mean, this one, this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanawa or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Catherine McBanawa or other persons.
Family's leaving. Looks like Dan Markel's parents may have just left.
It is not necessary that the agreement conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. And lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired.
Counted it. Got it.
As to the affirmative defense, I am not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
We agree, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following two elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanawa, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes.
Yes, Your Honor.
This is normal charging. Why is RA acting like it's not? This is normal. These are the jury instructions. They're talking about pattern jury instructions. They're modifying them a little bit.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanawa or other persons to commit first-degree murder. During the solicitation, which are being requested by the state.
The conspiracy charge is the one the defense did not ask for judgment of acquittal on. They fought 1 and 3, but as to 2, conspiracy, they basically waved the white flag and say, yeah, you got us on that one. So.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson, or Catherine McBanawa, or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area...
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the two principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation with murder as they have previously been defined. Or do we need to...
Defense?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the two instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter whether it can be argued that someone is a principal and solicitor.
Thank you.
The police in Massachusetts have responded, saying they're aware of the threat. They're asking anyone for information to contact them. But apparently they have not located anything.
It just needs to be clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately no instruction can be argued as to a defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
Hope it helps, Judy. We'll see you. Thanks.
And I will just add at the bottom the principal theory. Or actually, this instruction does not apply to count 2. And I will do that for both principal instructions. Moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
There's a speaker for the prosecution. I believe his name is Mr. Evans, sitting next to
Intent
Georgia.
instruction that will remain.
We would object, Your
What is the basis?
basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
It's probably number 10 is the only one we're not questioning. So 6, 7, 8, and 9.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify?
Pianos,
Number 7,
trailers,
had any
teeth.
pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you. Would you like to?
Yes.
Copy to the defense. Sorry about the typo in the title. And the certificate of service. It's all on Mr. Evans.
George blames Mr. Evans
Right,
for all the
as to the
mistakes.
requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
Goes to their credibility. This is the curative instruction the judge said he would not be opposed to giving to the jury about the sequestration violations. Basically, the state gets to say, when you're judging credibility, judge whether or not they follow the judge's instructions or the law. Super T.
I have an objection to the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, basically, witness's presence in the courtroom was based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think
February.
the first one is an accurate statement of law, but under the facts, the second one would be inappropriate.
Kappelman, what is your argument for the giving of the second?
It covers both. Covers both sequestration violations.
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it has just dawned on me where you're sticking the previous requested instruction about the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now.
We're keeping an eye on that Kentucky case. There's Brian Enton's done a lot of good work on that as well.
Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
They have to turn on the courtroom condenser microphone, which hears all the AC noise that you hear here.
You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested?
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManaway and to Mr. Rivera.
State.
So, it's fine here. So we're, for the record, as I understand it, the bracketed languages under accomplices and informants,
who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
All right, yes, sir.
Well, the judge is
While a
typing.
witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That will be given. And be given all cases, you may rely upon your own conclusion about the credibility of any witness. That will be given. Defendant not testifying. This will be given in full.
There's a viral video out there.
And we'll just change the pronouns to all feminine.
On social media.
The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made.
I left you guys hanging.
As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
The videos of Chuck E. Cheese getting arrested for a credit card fraud or theft.
Rules for deliberation.
This judge has that case. The Chuck E. Cheese being
Standard
arrested.
instruction. This will be given.
In full
Does
costume.
either party wish to be heard?
So right after this case is over, Judge Everett gets to
Cautionary instruction. Does either party
E.
wish to be
Cheese.
heard?
No, sir. No, Your Honor.
Single defendant, multiple counts. Does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
But Chuck E. Cheese being let out of the restaurant.
Moving on to the verdict
It's a
form.
restaurant. What do you call it? The facility in
Count
handcuffs.
1, we the jury finds as follows. As to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first-degree murder. Option B, defendant is guilty of the lesser-included offense of second-degree murder. Option C, the defendant is guilty of the lesser-included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option since she has the presumption of innocence. We
I
would
like
also
that.
request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is to raise?
The only thing I would suggest we leave them involved. It makes it clearer for the jury to differentiate between each of the counts, but I don't have any real strong feelings, but I see why they would be involved.
So you are requesting for it to remain the same or to not be bold?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we the jury finds as follows. As to count 2 of the indictment, conspiracy to commit murder. Check only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count 1?
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
The the same reason why I'm asking for the names of the charges to be in regular caps, not all caps, throughout the instructions. It's the same principle.
State, do you have a position?
Your Honor, I think it's
Caps and standard.
when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it the most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count one, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C, so it's not up under the check box. But other than that, I think throughout the verdict form we're going to be asking the same thing. Leave it as is, because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, we'll grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. Two options, guilty and not guilty for count 2. Same two options for count 3, guilty and not guilty.
Would suggest, Your Honor, for count 3 that you move it off page 16 to the top of page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages.
Thank you, sir.
All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
Okay, we're getting close to
How
the
much
end.
time is each party anticipating for their closing argument?
Hour and a half tops.
2 hours, Your Honor.
Oh!
We would say the same, Your Honor?
Very well. Both parties will have
We're gonna be here
2
all
hours
day.
to present their arguments. Ms. Kappelman, yours will be broken up based on
To be bifurcated.
what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2
She
hours.
smiled.
Oh, don't be too much.
Don't help
Submitting
me too
the
much,
case
she
to
says.
jury. Just with the time. Nothing else. Any objection or request?
This is standard.
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Kim R., congratulations, 27 months.
A demonstrative is not admitted, so yes, I would agree. It is not to go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before they're sent back.
All right, and I will just leave it then. Photographic discs, jump drives, reports, and document. Exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing.
Oh, gee. I need a button that says that, like a "that's easy" button. I don't know why I picked up
Final
a couch for that.
instruction when we reach the end of the case. Instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
I make a special request.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested
want special
within
treats.
3.5A for manslaughter. It is not necessary for the state to prove the defendant intended the death of Daniel Markel. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically as to count 3?
It's specific. Principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right. Once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
We're in recess. With that, we're done. I'd really like to see what the... I want a close-up of the audio-video guy, the back of his monitor. I'm trying to find the brand of monitors he has up on that tilted display. I think they're made by a company called Feel World, which is a Chinese knockoff brand. But if anybody can do the hard work, I'll show you real quick. Let me show you what I'm talking about. Jump to the end. That's not it. Hang on. They stood up too fast. Okay. This is my nerd moment, okay? Sorry, Mr. Prosecutor, to catch your face in here like that. But I'm looking... This item that's straight above me that has those rows of dots, I just need the brand on that one. I've done the Google camera, lens, everything. I just can't find what it is. So, all right. Here's what I want to do. I know we have possibly a palate cleanser. We've got rumors that there's like a crazy driver that was arrested up in Thurston, Washington for a trial that we need to look out for. Call the courtroom and ask. It's not the courts. It's the pool TV guy. Dallas-born, Boston-bred, OG, member for 31 months. What in the world will the defense say for 2 hours? It wasn't me. It wasn't me. I think we have to cue that song up and just take the copyright strike. That's what they're going to play. XLR, I think they're SDI. I know they're monitors because the guy who's sitting in front of them is watching screens. He's not doing the audio work. You can see back there. Well, sort of. You can't see, but. Are we going to hear this part? What are we doing? Apparently nothing. All right. Anyway, the McNally thing is great. I think I'm going to record that, Josh. And because tomorrow we have 4 hours of closing arguments, probably half an hour of jury instructions, and then we're going to be in verdict watch. And I want to use it for verdict watch if we can, because that would be really cool. Broadcast monitors, we'll find them. Thank you, Kent. If you find them, just send me a text on the burner phone. I'm slowly building my wish list for a flight pack, a flight case of equipment that I can travel with instead of tearing apart my studio every time we have a remote gig somewhere. So, who goes first tomorrow? Defense? No, in this case it's going to be prosecution first, then defense, and then prosecution again. But they're going to get the same amount of time. So even though, let me turn that off so it doesn't get loud. So even though they go twice, they get the same amount of time, so it's fair. We'll do a verdict poll tomorrow. We can do that, an official one. Let's see. I think you need to compose an AI song for this trial. There's been some funny things that might work. I don't know. We'll see. I'm predicting less than 2 hours for a verdict. It took 3 for Charlie's case, so that would be quick. And then the big question, of course, is what happens after a verdict comes in? If it's a guilty verdict, do we expect to hear news later in the day of an arrest? Or a warrant going out? An arrest in an airport? Matthias reached out to me. I know where he's at. I'm not sure if he's sharing anything right now, but he's reached out to me. Question is, will defense be ready for closings, or will they need a moment? All the other jewels. That would be epic. That would be epic. Your Honor, sorry, it's been a long case. Can we get like 15 minutes? 15 minutes just for me to organize my thoughts before I talk for 2 hours nonstop. That'd be amazing. Can the song be called I Don't Recall? It's a country song. I can hear the drawl in it already. All right. That said, tonight, just like last night, my wife and I we do a thing where we take each one of our kids out on a date with us. So it's like just us and them. And so we leave the rest of the family home. Tonight we've got another one of those going on. So I'm going to go out to dinner with my third oldest child tonight, and it should be a blast. I benefit. I just get to go out to eat every night. And so this is a win-win for me. Plus I get to spend time with people I love, which is always good. So that's coming up. And I've been starving myself intentionally. Maybe last night we went to Chili's. Had Chili's. Because the son we took has never really been one to go to restaurants. And so we wanted, as he goes out on his own, to just explain how things work. And this is how you talk to the waiter, and this is how you pay your bill, and this is how you order, and if you're going on a date, things like that. This next son has probably got that down pat, so we might go somewhere else. Maybe we can do an all-you-can-eat somewhere, a buffet. I know I'm gonna put my vote in for a buffet, possibly pizza buffet if there is one. Eat as much as you can. Yeah. All right. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We will live again tomorrow. They were going to start at 8:45 in the morning, so we'll be here at 8:30. 8:30 we'll start. Remember, we have it's Podcast Thursday tomorrow at 8 p.m., so hopefully the verdict won't go that long. But be here in the morning. We're going to sing happy birthday to everyone whose birthday it is, and we're going to just hang out. It's going to be some fun stuff to watch tomorrow. Josh is going to put in some serious work. We're going to find some great videos. You're going to love it. Thanks all for being here. Appreciate you. Mods, you're wonderful. Couldn't do this without you. And be good. Be good. If you can't be good at what you do, right? Don't get caught. All right. No more advice. We'll see you in the morning. Bye-bye.
Because we here in Canada hate you and hope for bad things for you because we hate you.